Good morning, Malaysia. Welcome to Legal Hotline 199. I'm your host for today's episode, Mr. Adil Faiz. Before we get into our caller session, let me introduce our expert panel for today's episode.
Hi, my name is Kalish and I am a consumer law specialist.
And I'm Shweta, I'm a tribunal and ADR expert.
So speaking of tribunal, let me give a quick introduction for our viewers. So a tribunal is a special legal body that helps people to settle dispute in a specific area of law. So in Malaysia, we have Tribunal for Consumer Claim Malaysia or TTPM, which created under the Consumer Protection Act 1999. So now that you know how the tribunal background, so let's move on to our first caller. Hello and welcome to Legal Hotline 199. So who is there?
Hello, my name is Mrs. Lim and I recently purchased a high-end washing machine from a retailer in Kuala Lumpur. However, after 2 months of using it, the washing machine had spoiled, water was leaking from it and there was electrical faults. So I asked the retailer for a refund, however they refused to give me a refund or even replace me with a new washing machine. What can I do? I don't want to bring this claim to the court. My claim is around RM 20,000 and I would like to ask if I can bring my claim to the Consumer Claims Tribunal. Can I do so?
Thank you, Mrs. Lim, for sharing your problem with us today. So now let's get insight from our expert.
First of all, it's important to understand what a tribunal is. So basically, a tribunal is a legally established body that has its own authority to resolve specific disputes. It protects individuals better than decisions by government. And it is much faster, less formal, and far cheaper than going to the court. That's why many consumers choose it. Okay, as for the law, the Consumer Protection Act 1999 governs this area. Under Section 2, Subsection 1, the Act applies to all goods and services supplied to consumers, including online transactions. So, household items like washing machines falls directly under this Act. Okay, next is Section 3, Subsection 1, tell us who a consumer is. So basically, a consumer is someone who buys goods for personal or household use and not for business or resale. So Mrs. Lim is clearly a consumer because she bought the washing machine for home use. Okay, under Section 97, a consumer who suffers any loss related to their rights under the CPA may file a claim with the tribunal using the prescribed form and a small filing fee. And importantly, Section 98, Subsection 1 explains that the tribunal can hear claims up to RM 50,000. So Mrs. Lim RM 20,000's claim is well within the limit, so the tribunal has the full jurisdictions. So now, the central issue here is whether the washing machine was of acceptable quality. So we look into Section 32, Subsection 1 requires that all goods supplied to a consumer to be of acceptable quality. Section 32, Subsection 2 clarifies that goods must be fit for their usual purpose, safe, durable, free from minor defects, and acceptable in appearance. If a product fails to meet these standards, the law gives clear remedies. Section 41, Subsection 1, Para A allows the consumer to require the supplier to fix the defect. Section 41, Subsection 2 goes further. It lets the consumer claim additional damages for any loss caused by the defect. Finally, under Section 42, Subsection 1, the supplier has several options to remedy the failure. They can repair the goods, replace the item with identical goods, fix any little issues, or refund the full purchase price if repair or replacement isn't reasonable. So based on this section, Mrs. Lim has a strong consumer protection rights.
To support that, there are two important cases. First is Su Tiang Ju vs. Tribunal for Consumer Claims. In this case, the consumer bought a Mercedes-Benz and experienced defects. The tribunal awarded him compensation and the court later confirmed that he had the right to make the claim. The court also emphasized that tribunal decisions are final and binding unless there is a clear legal error. The case shows two things. One, the tribunal properly protects consumers who face defective goods, even expensive items. Two, the courts will not interfere with the tribunal's decision unless something is clearly very wrong. Another useful case is Madin Al-Sharif Travel vs. Tribunal Pengguna. Here, a travel agency tried to avoid responsibility for consumers who never received their Umrah packages. They didn't attend the tribunal hearings and the tribunal ordered them to refund the consumers. When they tried to challenge it, the High Court dismissed their application and upheld the tribunal's award. This case confirmed that tribunal's award stands firm and companies cannot easily escape liability. It also shows the tribunal's role in protecting consumers who suffer losses. So, when we apply these legal principles to Mrs. Lim's issues, the law strongly supports her rights to seek remedies at the tribunal.
Now, let's apply the law directly to Mrs. Lim's situation. So first, she clearly qualifies as a consumer under Section 3, Subsection 1 of the Consumer Protection Act because she bought the washing machine for personal household use. That means she is fully entitled to bring her claim to the tribunal. Next, her claim amount is RM20,000. Under Section 98 subsection 1, the tribunal can hear claims up to RM50,000. So Mrs. Lim's claim falls well within the tribunal's jurisdiction. This also gives her a more affordable and faster alternative compared to filing a full court case.
On the merits of her case, the law is very clear. Section 32 subsection 1 says all goods supplied to the consumers must be of acceptable quality, and Section 32 subsection 2 explains that acceptable quality includes being fit for use, safe, durable and free from defects. The machine malfunctioned after just 2 months. It leaked and had electrical faults. That is a clear breach of the required acceptable quality, especially for a high-end appliance that should have lasted much longer. Because the retailer refused to replace or refund the machine, they failed to remedy the defect. Under Section 41(1)(a) and Section 42(1), Mrs. Lim has the right to reject the goods and require a proper remedy, which may include repair, replacement or even a full refund. She also has the right under Section 41(2) to claim damages for inconvenience caused by the leakage and electrical faults, as long as she can show the loss. And importantly, the case law supports the proposition. In Su Tiang-Ju vs. Tribunal for Consumer Claims, the court confirmed that consumers have the right to bring claims like this and that the tribunal's decisions are binding. The Madin Al-Sharif travel case reinforces this. Companies cannot simply deny responsibility or blame the consumer. The tribunal still has full power to hear the claim and hold the supplier accountable. So, applying all of this, Mrs. Lim has a strong legal basis to proceed with her 20,000 ringgit claim at the tribunal.
In conclusion, Mrs. Lim have every right to bring her case to the tribunal since the tribunal court has full jurisdiction to hear this case. So stay tuned for episode 2 for Legal Hotline 199.
To another episode of Legal Hotline 199. I'm your host Shweta. Today we discuss disputes arising from unfinished renovation work, which is a common problem for homeowners. Let's introduce our panel first.
Hello everyone, my name is Mr. Adil Faiz and I'm a construction lawyer.
Hi everyone, my name is Jasrina and I'm a consumer tribunal strategist.
Hello, you're live on Legal Hotline 199. Who's calling?
Hi, my name is Ahmad. So basically, I hired a contractor to renovate my house, but they didn't complete it. So my total loss is RM40,000. So can I go to tribunal or should I go to the court?
Thank you, Mr. Ahmad. Now let's hear from our experts.
Let's break down the law that applies to Mrs. Ahmad case. So first, Section 2 Subsection 1 of the Consumer Protection Act 1999 states that the Act covers all goods and services supplied in trade. So next, we have Section 3 Subsection 1, which defines a consumer as someone who acquires goods or services for personal use, which includes home renovation in this case. So next, we also have Section 98 Subsection 1, which gives the tribunal court authority to hear consumer claim as long as the matters involve goods or service and the amount claimed doesn't exceed RM50,000. Since Mr. Ahmad's claim is 40,000, it fits squarely within the tribunal limit. So move on to the next section. We have Section 53, 54 and also 55, which sets out the implies guarantee for service. So Section 53 explains that it requires the contractor to carry out renovation work with reasonable care and skills. Section 54 ensures that the service must be fit for the intended purpose. So lastly, we have Section 55, which will require the work to be completed within a reasonable time.
One important case would be the case of Hello Holidays Sdn Bhd versus Pang Lai Sim. So basically, in this case, the court confirmed that the services, including tour packages, fall under the Consumer Protection Act. And the tribunal was right to apply Section 53, and the High Court upheld the tribunal's decision. This shows that the tribunal has a strong authority when dealing with service-related disputes. Another relevant case would be the case of Li Yuanxiang versus Wang Niyan, where in this case, the court clearly stated that due to renovation works, they are considered as services under Section 3 and Section 53 of the Consumer Protection Act. Because the homeowner hired the contractors for personal and household purposes, she was considered a consumer and the tribunal had the full jurisdiction to hear the complaint. These cases confirm that the tribunal is the correct forum for renovation disputes. If the work is poor, incomplete or delayed, the tribunal has the power to decide the case and grant remedies.
Applying the law into Mrs. Ahmad case, so hiring a contractor for home renovation is clearly a service acquired for personal household purpose. So this makes him a consumer under Section 3 Subsection 1 of the Consumer Protection Act 1999. So the renovation works count as service, just like how tour package were considered service in Hello Holidays against Pang Lai Sim. So, Mrs. Ahmad, this clearly is a matter under Consumer Protection Act.
So looking at the merits of the case, the contractor had failed to complete the project. This breaches Section 53, which requires services to be performed with reasonable care and skill. It also breaches Section 54 because the renovation was not fit for the intended result, a fully completed home, and Section 55 since the work was not done within a reasonable time. So the cases support this, where in the case of Hello Holidays, the tribunal applied the implied guarantees to tour services, and the High Court confirmed that such services fall under the CPA. Similarly, in Li Yuan-Sang vs. Wong Mi-Yan, it specifically recognized renovation works as services under the CPA and confirmed that the tribunal has jurisdiction. So finally, under Section 98(1) of the CPA, the tribunal can hear claims up to 50,000 ringgit. So Mr. Ahmad's claim is RM 40,000. So it is within this limit, and so applying both the law and the cases, Mr. Ahmad can bring his renovation dispute to the tribunal rather than going to the court, and he has a strong basis to do so.
To wrap up, Mr. Ahmad can definitely bring his 40,000 ringgit renovation dispute to the Consumer Claims Tribunal. He qualifies as a consumer and his claim is within the tribunal's RM 50,000 limit. So the tribunal has full authority to hear and resolve his case. Thank you Faiz and Jasrina for your insights, and thank you Mr. Ahmad for sharing your experience. Stay tuned to Legal Hotline 199 for more cases.